So, once you've got an idea, you kind of want to put it in some type of entity. Try to create some entity other than just yourself, so that you can, in a lot of cases, you can keep your finances separate, you can keep your activities separate. So the most straightforward and easiest and cheapest entity formation is just a DBA, an assumed name certificate, down at County Hall. I think they charge $35 or something like that. And then that allows you to open a bank account and kind of pick whatever name that you want to use if you don't want to use your own name for your business. The upside is that it's quick and easy. It allows you to open a separate bank account, keep track of your finances a little bit separately. The downside is that it doesn't really protect you from any liability. So in order to take the next step and find a way to protect yourself from liability, you have to go to the state and form either an incorporation or an LLC. Those are the main two options. The benefit of the incorporation is that you can sell off shares, not on the stock market, but sell shares or ownership rights to the incorporation to potential investors. So then they have rights to some of your profits, but you've gotten some investment from them. The LLC structure is really nice because it's got what are called flow-through tax benefits. So any of the money that you make, it isn't taxed at the entity level, it's just taxed at the personal income level. The new tax bill that was signed into law earlier in 2018 has changed that a little bit so that the incorporations have a little bit, I believe their tax rate was lowered quite a bit. So I'm not an accountant or a tax attorney, so I'm not super familiar with everything that's going on with the new tax law, but there are some benefits there for the incorporations. So typically the businesses that we help, they usually start up with an LLC. It's just a little bit easier for everybody to start up with that format. And most people aren't able to line up investors that are looking for ownership interests in their business. So that's where the LLC can be really helpful. So the general category of intellectual property includes patents, trademarks, and copyrights, and a lot of people get these things kind of confused. The patent covers an invention. So anything that's new, useful, and non-obvious as an invention is covered by patent law. An improvement on an air conditioner, or an improvement on a heating system or solar panels, anything like that would be, subject to patent law. So that covers, so those are what the inventions are. And then the patent application, it discloses everything about your invention. You file that, you ask the patent office for patent rights. They usually say no at the outset, and then it comes back to us, we make some arguments, and then we turn it around, and then they usually say yes at the second step. Not always, but usually. So the patents can be very helpful. It keeps other people out of your space. There is a patent application, it's called a provisional patent application, and then a non-provisional. The provisional patent application is really beneficial to startups and solo inventors, and I think I just learned this word, solopreneurs, instead of entrepreneurs. It's just a solopreneur. I don't know why we needed another word, but so for individuals like that, they can get something on file. It's a little bit cheaper, it's a little bit faster. Then that allows you to market your invention as patent pending for 1 year. You can go out and look for investors. You can see you can market your product, see whether people are interested in it, and then kind of go from there. So hopefully at the 6-month mark, people are really interested in your product, and then you move forward with the non-provisional, which is where you're actually asking for the grant of patent rights from the U.S. Patent and Trademark Office.
What happens if you don't get an actual patent after the provisional? What if your one year is up? Does that mean your idea is public domain now?
Not necessarily. It depends on how you treated it. So at the 1 year mark, The provisional patent application expires. An issued United States patent will never issue from a provisional patent application, only from a non-provisional. So I kind of call it a placeholder. So you go to the patent office and you say, hey, hold my place, but I want today's date to be my placeholder, and dates are important in patent law. So, so at 1 year, if you don't file a non-provisional, it just expires. If you haven't disclosed it to anybody, it doesn't become public domain because it just sits at the patent office and it doesn't do anything. But if you have disclosed it, then once the provisional expires, you no longer have patent pending rights, and somebody else could take your invention and market it and sell it themselves. So the non-provisional, unless you're really having zero success and you have absolutely no money and you just can't take the next step, the non-provisional usually is the next step that our inventors take. But it's very beneficial for our startup companies and individual inventors.
To do the 1 year?
Yeah, and then follow up at the 1 year mark with the non-provisional. For bigger businesses, a lot of times, if they've been doing this for a long time, they know that their invention is going to be successful, and they know that it works, and they know they're going to be able to market it, so they'll just go ahead and start with the non-provisional. So that's always an option. As patent attorneys, we much prefer writing the non-provisionals because there's a lot more work and it gets a little grittier, and it's just a lot more interesting for us. But the provisional is typically the best course for smaller businesses and startups.
Is it possible after the provisional to get denied for the non-provisional?
Yeah, it typically does get denied the first time. So you file a provisional, all it does is it sits at the patent office and just is holding your date, today's date. And then at the 1 year mark, we file a non-provisional patent application, and then that gets examined by the patent office. And it usually does get rejected the first time, but then we make arguments and then they usually allow it.
And do you really have to have a meeting, like with yourself, to even know if your idea is patentable? It might be a new idea that's not out there.
Right.
But like a car, you would think that a car could have been patented years ago, but yet
Yeah.
look at all the different varieties of vehicles that have 4 wheels with an engine, with axles.
Right, yeah, that would have been patented initially many, over 100 years ago.
Oh, okay.
So then any new advances would be, so for a car, at some point the intermittent windshield wiper was patented.
Right.
A different braking system would be patented. An improvement on a car's air conditioning system would be patented. So GM and Ford and Mercedes-Benz, for example, all of those companies have huge patent portfolios.
Right. But you could have an idea today that isn't patentable, but you could start a company with it.
You could, yeah.
Yeah.
There's a couple different things. There's patentable subject matter, and that just means that your invention or your idea falls within the categories that are patent eligible.
Right.
From there, that invention needs to be new. New is very easy. I mean,
Right.
you just change something very, something minimal. But it does need to be non-obvious. So in the world of air conditioners, something that improves the efficiency, reduces the electrical consumption, improves output, anything like that would be an improvement and would likely be considered non-obvious.
Mhm.
If you do the provisional patent, after 1 year, can you renew a provisional, or does it have to go to a non?
You can't renew it, but you can refile it as long as you haven't disclosed it. So what you end up giving up is the priority date. So if we file something today, and in 1 year, you've made some progress, but not as much as you thought, you've lined up some investors, but not as many as you thought, we can refile it, but the old date, it goes away. So within this year, if you've kept it confidential, as long as nobody else came along here and invented the same exact thing and filed a patent application, then this newer date that you get is, that'll be good enough. So we have had clients do that where they just didn't make enough progress, but they didn't tell anybody about it. But one issue that can come up is if you file something if you file something on this day and then you disclose it here, that's, you have a year to get something on file, but you get the provisional, the second provisional on file, so you'd be okay, but then the third provisional wouldn't work. That's probably way more complicated than you needed to think about. But that's what attorneys are always thinking about, not blowing deadlines.
Okay.
If you If you change something, let's say you have an idea, you think it's going to work like this, and then in that year you tweak it, you change it, you
Yeah.
find a little bit better ways of doing it, is that still covered under it? Or like how much do you have to keep the same, or is there
Well,
ways?
that's one of the benefits of the provisional. If you find that it's working a little bit better, at the time of the non-provisional, you can make those changes. So now those new changes won't get, this is another complicated legal thing, but the changes that you've added, they don't get credit for this earlier date, but they're covered in the non-provisional. And they've kind of grown off of this earlier date, so in most cases, it's fine.
Okay.
We have had clients do that before too.
What if you disclose your idea to someone in another country? So let's say you had an idea, you wanted to get a quote for it for manufacturing, and you sent it
yeah.
to China to look at it. Because they're not in the US, does it change the game?
You can, if you've got a provisional on file, that will serve as an international filing date. But you have to come in within 1 year and file in all of the foreign countries that you want to.
Okay.
So if you've got a provisional here, contact China here, and if you want to protect it in China, at the 1 year mark when you do the non-provisional, you have to also file another application that will protect you in China. There are 2 ways of doing that.
Is it, it's more expensive than to file it in, like, is it just like you file it in multiple countries, or every country you want to file it in is an extra how many dollars?
I can't answer that because it's so broad. Japan is horrendously
Okay.
expensive, and then some of the other countries are fairly inexpensive.
Okay, yeah.
But yeah, there's one way you can file what's called a PCT application, and that gets you potential rights in over 180 countries if at that point you still don't know where you want to go. So the PCT is typically used by large companies. They're like, we know we want to market this in different countries, but we don't know where yet. Let's file the PCT. It's about $5,000, I think. And that gets you potential rights, but you still have to individually enter each country.
Okay.
So for some of the larger companies, as you can imagine, that gets very, very expensive. For most of our inventors, the only country we typically encourage outside of the United States is Canada. And that's just because we're right at the border. If you're having something made in China and they bring it back and they're making it over here and selling it on their own in China, probably not going to worry about that too much. But if they start making it for another company who then imports it into the United States, then your patent blocks them from doing that.
Okay.
So that's a great question, especially for people that are manufacturing in China. So ideally, in any case, you get the provisional on file before you do too much of anything else.
Okay.
And then you kind of follow it up with non-disclosure agreements so that when you disclose it to somebody that needs to make a prototype or manufacture it for you, they're not allowed to disclose it past themselves. So,
Great, thank you.
it's kind of complicated. That was a good question though.
But China's notorious for doing knockoffs and that,
Yeah.
even if you have patents, right?
Yeah,
But
they're-
if you have the patent, then at least the law enforcement can confiscate
right,
if they can catch it?
Yeah, if they catch it coming in through the border, then they can confiscate it
Yeah.
and destroy it. So if it's going to your competitor, that's what you want to do.
So does that mean every import that comes in, this is something I don't know, every import that comes in, they do searches on the products?
No, you as a patent owner have to specifically ask them to look for that.
Okay.
So if you have evidence that something's coming in, then you can sort of, reverse engineer to which port it's coming in, and then they can do searches.
And that's not something they generally do, is look for knockoff products and look at patents for everything that's imported.
No, I think just anything that's glaring and that sticks out.
Because that would explain how long it takes to import things, but.
Yeah, no, that's not the issue. So the trademark covers, everybody's always asking, wait, you get to own words? This means you own words? It doesn't actually mean that you own the words, but you have ownership rights to those words in connection with your goods and services. So if you think of Spot Coffee, they own the phrase Spot Coffee in connection with cafe services, baked goods, coffee. So if you want to start a new coffee company and call yourself Spot, you're not going to be able to do it. But if you wanted to open up, like, let's say an exercise facility, you could call yourself Spot Physical Training Center or something, because gym services are far enough away from coffee services that no one would think Spot Coffee got into the business of offering gym memberships. So sort of an odd example,
It
but
makes sense.
yeah.
That's perfect.
Yeah.
So that's what's meant by different classes of goods and services. There are 44 different classes. So most businesses, they just fit into one class. So there are additional fees if you go into a second class, but most businesses are just in one, especially when you're starting out, and then maybe later on you branch into something else.
I'm kind of curious what those classes are. Are they listed online anywhere? Or?
Yeah, under, you can look up under WIPO and the NICE classifications. But the first one is just all chemical compounds. There's metal materials, business services, educational services. But you can look it up.
Is that WIPO?
Yeah, I think
WIPO.
.org. But you can do NICE trademark classification and it should come up.
Okay.
So Nice, France, so it's not spelled like nice.
So it's NEICE or something?
Yeah. So some of the classes are pretty broad. So for some of our clients, I have a client that's doing real estate and financial advice and estate law or estate services, and that's all just in one class, so they didn't have to pay additional fees for that.
And when you initially get a trademark, it'll cover you just in one class?
Right, correct. So it may indirectly cover you in a second class if somebody starts doing something that's really, really close to yours, to what you're doing. Maybe if somebody tried to do coffee delivery services or something like that, and they called themselves Spot. Spot's really over here, but most people could see, oh wait, Spot, oh they started delivering now.
Right.
But it's different, it's a different company, so that's gonna be too close.
Gotcha.
So that's a really bad example, but I can't think of anything offhand.
But it makes sense.
Yeah,
Here's-
yeah. It's the point of trademark law is actually to protect the consumer. So they need to have a good understanding of where their goods and services are coming from. So if you're familiar with Spot Coffee and you like their coffee and everything about them, and then a new company comes along and they're delivering coffee and then you buy it and it's terrible, but you thought it was Spot, well you haven't been protected then because you had no way of knowing that it wasn't the regular Spot. So that's really the point of it.